Welcome to the Climate Trends podcast, where we unpack pivotal stories redefining the response to climate change. Today's episode zeroes in on a historic moment, the recent International Court of Justice advisory ruling on climate change. And to unpack that, we have with us Joie Chowdhury. She's a Senior Attorney, Climate and Energy Program at the Center for International Environmental Law. And with her, we'll break down what this landmark decision actually says, how significant it is for on the world stage, and what kinds of legal and political momentum it might set in motion for countries elsewhere. Thanks so much for taking the time to join our podcast today.
Thank you so much for having me.
Yeah. So, Joy, before we dive into the specifics, I think it's worth noting that this ruling comes at a particularly charged moment globally because we're seeing renewed climate policy tensions, shifts in international cooperation, and of course, the countries are grappling with how to balance their economic interests and pressures with their climate commitments. So, this ICJ opinion seems to really cut through a lot of that complexity with some very clear legal guidance. So maybe we can start from the ground up and we can start with just breaking down what exactly happened there. So it might seem like an impossible task, but if you can help the listeners understand in very simple terms what was the ruling actually all about, and maybe you could also give in a very brief nutshell what is International Court of Justice and why is this decision so monumental.
Sure, happy to. Well, the International Court of Justice, the ICJ, it's the principal judicial organ of the United Nations. It essentially settles legal disputes between states. It also provides guidance on legal questions, as it did in this case. And colloquially, it's known as the world's highest court, and its work holds great authority. And this case, exactly as you mentioned, at this moment, we are seeing a difficult multilateral context. We are seeing climate devastation accelerating worldwide. We're seeing climate destructive conduct too often evading accountability. And in this moment, in particular, this ruling is historic. It could potentially be one of the most legally consequential cases of our times. And what it does is it cuts through the noise. It definitively provides a pathway to move beyond the voluntary pledges, the promises, the vague, we will do XYZ and then not delivering, and really grounds climate ambition in legal obligation. In short, the ruling essentially changes the legal landscape, putting the weight of international law behind climate action and firmly on the side of people and the planet. And then the last thing I'll mention, it's monumental not just because of the outcome, but also because of the process. Because beyond the outcome, the proceedings itself saw unprecedented state participation. Just in the oral hearings itself, 96 states participated. And the case itself was born out of a classroom in the Pacific. It was driven by students and young campaigners from all over the world. And you saw unprecedented, extraordinary alignment on climate justice arguments inside the courtroom. So this process itself has shifted the way in which international law is practiced, and that will have ripple effects as well.
Right. Yeah. And if you could also attempt to summarize a few key points from the advisory.
Absolutely. So what the court essentially did was it provided clarity on states' obligations in relation to climate change. It provides a blueprint on how do we hold polluters accountable under multiple and complementary sources of international law, including, for example, the law of the sea, human rights, customary international law. And then, so it addressed the question, what obligations apply in terms of climate change? What are the legal obligations that apply? And then it also addressed the questions very clearly. Well, what are the consequences when states do not meet these obligations? And there it very clearly affirmed the right to a remedy and reparations.
Okay. Yeah. I'd love to dive into what the consequences that are defined. But before that, just to dial back, how did we get to this moment? What prompted countries to seek an advisory opinion in the first place? And yeah, what was like the origin of this historical legal process?
As I mentioned, the case was conceptualized in a classroom with 27 law students. And then it was taken forward by the Pacific Island students fighting climate change who approached Vanuatu to see if they would take on this case from a state perspective. Vanuatu did an incredible job in spearheading a diplomatic initiative that brought a lot of states on board. And then this went to the UN General Assembly. And we essentially saw a unanimous push to send this case, these questions, what are the obligations of states in relation to climate change and what happens when they don't meet those obligations, to the ICJ for its guidance on these very critical questions. And so that's how the case came about. And you saw over several years, you saw deep collaboration and coordination among states. We saw several stages of the proceedings. There was the written submissions, there was the very vibrant and dynamic oral proceedings. And you also saw a very strong kind of campaign being built up around the case. So there was the formal proceedings, but there was also mobilizations and frontline testimonies. And those were even brought together in very creative ways. So, for example, there was a Pacific and also global initiative called a witness stand, where you had frontline, those affected, very badly affected by climate impacts, coming and giving testimony before the camera. And then this witness stand was formally introduced in the record in the courtroom. So the judges had access to those very powerful testimonies as well. So there was very creative ways in which people and lawyers came together to create this extremely strong proceedings that led to this watershed outcome.
Yeah, it's actually so inspiring that in such a doom and gloom kind of a situation where we feel like people's voices are getting drowned out, and literally with what happened in Uttarakhand 2 days back, when houses get washed away, and with that goes away people's voices, this really did feel like, a ray of hope that there is still value in bringing forward testimonies of people. And I think it speaks a lot about where the climate leadership is coming from today. And it's, as you say, driven a lot by young people. And I'm wondering if you have something to share about that as well.
Absolutely. And before we even go there, I remember I did not fully answer your last question because you asked why did states bring this? And I think it is this gap that you mentioned between where the policies are of many of the states that are disproportionately contributing to the climate crisis, and what is required by justice and science. There is just this unconscionable gap there. And often people or states hide behind legal arguments to justify these very climate destructive, planet destroying policies. So states felt, those on the front lines felt, maybe legal clarity from a very authoritative body could help cut through some of this and really kind of strengthen positions that would help drive policy stronger climate ambitions. So that was one of the guiding forces, I think. And then in terms of the youth, I cannot say enough how much they have led this case from the beginning. It is profoundly important that this leadership was there because I think the outcomes really exemplify the power of the leadership by those most affected. And I think we've seen that. I mean, we've seen it in India, we've seen it across the world. When those most affected lead from the front, the outcomes are proportionately strong because it is a survival fight for many people in climate. And it meant so much from every stage of the proceeding, whether that was powerful campaigning outside of the courtrooms, whether that was engaging with their states. It is harder for states to ignore their youth when they come, right, with a very legitimate expectations that their states will do more, their states will support them in their efforts to protect their territories, their oceans, their communities. So there is a legitimacy there when you have youth leadership that I think is unmatched in its power and its authority. You had storytelling that was happening. It was just coalition building. throughout the world. You had it sparked up from the Pacific, but you had like a global coalition of youth campaigners and young lawyers really leading from the front. And I felt there was this absolute rejection of an incremental approach. It was, this is what is needed at this moment. This is what we will do. We do not care if there are more traditional forms of approaching the law. We will approach the law with the strongest climate justice approach possible. And I think because of the strength of that belief, we saw the very strong outcome that we did.
We saw a slight departure from the norm, when climate negotiations usually see a familiar north-south divide. But what was different about the division at the ICJ court proceedings, and what does ICJ in that sense say about historical responsibilities when there is not that clear division that you otherwise see at other climate forums?
I think in climate forums, you often manifest through country alliances, country groups. And then also because of how the climate treaties are set up with the Annex 1 countries and the Annex 2 countries, the ways the division set out there is dictated by the characteristics of those specific spaces. And here you saw the legal arguments and country divides happening between kind of the differentiation that we saw was along the lines of the legal arguments being posed. And certain legal arguments are not tenable. They were where you saw the strongest pushback against climate justice positions, the arguments that were being forwarded, that were being advanced in the court, were not arguments that really hold water. And I do think that because it's not behind closed doors, like often happens in negotiations, you are actually going out there under the lens of the entire world watching. So many people were galvanized by this case. So many people had eyes on this case. To be able to come out and put forward disingenuous arguments, to put forward arguments that do not hold up when a strong legal lens is applied. I think we only saw that from the major polluters. And in fact, we saw an overwhelming consensus on climate justice positions from majority of the delegations that were present. So I'll stop there. But you also asked about historical responsibility. And yes, this case was so monumental because it represents the past, present, and future of climate action. At its core, it addresses historical responsibility because we cannot address the climate crisis without tackling its roots. And the court made very clear that, of course, it's cumulative emissions. Present emissions matter, but also historical emissions really matter and really need to be taken into account in our climate response. And in terms of equity, it also had a strong pronouncement that CBDR, the common but differentiated responsibilities, and equity must be a guiding principle across the legal obligations that apply in relation to climate change, and of course are there as part of specific treaty obligations and customary obligations as customary law obligations as well.
I'm also curious how, because the way the court approached was different from how negotiations happen in closed doors. How did the countries respond during the proceedings and the final ruling? Was there something unexpected in terms of reactions from the countries?
During the rulings, there are these existential stakes, and your submissions are very public, right? Whether you're doing writing or. What we saw was a few major contributors to the climate crisis. They were seeking to avoid legal responsibilities by downplaying obligations, overstating complexities, ignoring historical emissions. But most nations and international organizations that participated in the proceedings, led by frontline countries, led by climate vulnerable global south countries, they were basically arguing for a much broader framework incorporating equity, historical responsibility, self-determination, human rights of present and future generations. So I think that overwhelming kind of alignment around climate justice really supported the court in the outcome it delivered, in the opinion that it delivered, to really come down on the side of those on the front lines and to give an opinion that's really rooted in climate justice and human rights.
So let's address also the elephant in the room. How does this ICJ opinion apply to the United States, especially now that President Trump has signed executive orders pulling the country out of Paris Agreement and all of the very difficult, not very climate friendly policies and conversations that come out from the US? How did this? How does the ruling apply to a country like the USA?
Well, it's important to remember that the ICJ ruling does not introduce new responsibilities. It confirms what existing law requires, including universally applicable law, which is customary international law, with which all states must apply. In fact, the obligations laid out in this opinion, they are not, they're not mere guidelines, they are binding rules of law, and they apply no matter which ways the political winds blow. And in fact, the court explicitly stated that climate obligations are erga omnes obligations, which essentially are obligations that apply to all states, that states owe to each other. And they apply whether or not they're party to the Paris Agreement. So we have a response there. And it is also important for us to recall that we saw unprecedented levels of participation in the ICJ climate case, right? Including from the United States. It submitted written submissions, it submitted comments, it came and argued before the court, and it provided very strong arguments. The United States has also in the past followed ICJ rulings, so it is not something that is outside of the scope. Obviously, it is a moment in the United States that we're seeing right now, but we are also seeing within the country pushback against some of the policies that are being proposed. And I think in certain ways, this case will strengthen the hands of the communities and states that are, that are bringing forward ways in which to protect the environment and protect their communities. So, the ruling does apply to the US, and there are very creative lawyers out there both within the country and outside that will be considering legal pathways.
Mm. So it offers a really strong, it strengthens arguments for people who are trying to push for better policies, and it's like a guiding force as well, the ruling. But as me being a layperson, and there are several confused people out there as well, if this opinion is not legally binding, then how can countries actually be held liable? And you had earlier mentioned that the ruling does define the consequences of breaching certain commitments. Or so how does that work when there is legal accountability without binding force?
Well, technically, yes, it is non binding because it is advisory in nature, but it is an authoritative interpretation of binding international law states have committed to. So if you have conduct now, if you have acts or omissions from states that is not in alignment with this interpretation, then it opens the door for legal action that can be taken in specific jurisdictions, and in these jurisdictions, those types of legal actions can absolutely have binding weight. So the law that is being applied in this case is binding law. And that has very serious legal implications for those whose conduct is not in line now with the interpretations laid out by the court, if that makes sense. And also, it's critical to recall that the power of the law is not only in its enforcement when disputes arise, but also in its capacity to prevent such disputes from arising in the first place by aligning understandings of what conduct is legally permissible and what conduct is not. And law is one of the most powerful tools to keep governments and companies in check. And as we discussed before, even amid some populist pushback that we're seeing against international institutions, we're simultaneously also seeing a rise in requests to international courts and tribunals for rulings and for dispute resolution, highlighting that they continue to play a very central role in interpreting and shaping um, the international community's norms and how we work together.
I think to a huge extent, the ruling does also influence domestic decision making. If we look at specific countries and governments wanting to expand their economies, and it might affect how they approach, granting permits for new projects that are not climate friendly going forward. So, is that something that you could also weigh in on in context of the global South or India? Like, how could this ruling influence domestic decision making with respect to climate action?
I think there are several pieces, right? Because as we know from the global South, the way climate impacts are experienced as human rights harm, for example, happens often because of inequalities amongst between countries, but also within countries. And so there are ways to both when global South governments are not in compliance with aspects of the ruling, it gives peoples and communities within the country additional legal tools now to hold their governments accountable. But it also allows the countries in the global South, our communities, the abilities to hold other countries and corporations accountable for climate harm that is being experienced in their territories. The historical responsibility piece is really critical for this, right? The remedy and reparations piece is really critical because, as we know, there are several cases being developed in many different countries around the role of corporations in the harm that they're experiencing, harm that many people in the front lines are experiencing without having contributed much or at all to the climate crisis as we know it. So, in many ways, what this ruling does, it strengthens the hands of those who are bearing the brunt of climate injustice. And I think we will see ripple effects in many different ways, and not just in litigation, right? Very much like you said, in domestic policy making, in international negotiations. Litigation is a really important tool, but we know we're not going to litigate our way out of the climate crisis. It has to be through transversal policy making and multilateral solutions as well. So, what this allows countries to do is also to see the decisions they're taking, is this in line with the court's ruling? And another last thing I'll mention is there was a very strong pronouncement from the court on the importance of having very ambitious NDCs, which are national plans, national climate plans. And this really matters because this is the year when we're seeing new NDCs coming in, and it provides a benchmark and a way to assess the strength of the NDCs that are coming in, and also maybe even to influence the NDCs that have not yet been submitted.
The ruling is come at a very interesting time, just ahead of COP30, which a lot of people are still, counting on some important announcements and outcomes from it. Um, in your opinion, would the ruling shape the negotiations and the commitments at the upcoming COP conference?
I think very much so, because what the court did was it defined the realm of legal frameworks that apply, the legal sources that apply in terms of climate change and states' legal duties. But one of the disingenuous kind of arguments that we saw put before the court was not only does, like many major polluters argue that, look, it's really only the Paris Agreement that applies in relation to climate change. And then the Paris Agreement doesn't really require us to do very much. So we basically do not have to do very much. And what the court came in and said, actually, no, there is this wide range of law that applies in relation to climate change that extends far beyond the climate treaties. But the climate treaties are also important and they have binding obligations. And this is what you're required to do in to be in compliance with the climate treaties. And if you're not in compliance with your obligations in the climate treaties, the law of state responsibility applies, triggering legal consequences. So, really, a lot of what we've seen at the UNFCCC space is major polluters trying to evade responsibility whatsoever. And I think the court has made very clear and has provided new red lines that these are not things we have to go back to the drawing table to renegotiate. This is clear in international law, and to be in compliance, you need to be acting in this specific way. So it gives small island states, states that are facing a lot of climate devastation, additional legal tools to fuel their positions at a space like COP. So I think we can really see climate finance discussions being influenced. We can see climate mitigation, global stocktake, which is about the implementation of Paris, being influenced, science becoming very, very central. So the court made it very clear that ambition under the climate treaties needs to keep us under 1.5, and that states' national level plans need to be in line to actually achieve that. So yeah, in many different ways, I think we can really expect that this opinion from the court, this ruling from the court, will be used in ways to hold countries accountable in very specific ways at the climate COPs, and for there to be less of this proliferation of voluntary pledges, and to really push us in a direction where countries are increasing their climate ambition.
Yeah, I think litigation tool has always been quietly working in the background, of the climate movement, and it's nice to see like this kind of a worldwide impact. Um, and I think it's definitely sends fully a deafening message to all the corporations, businesses, all the responsible parties who should be pulling up their socks. So I wanted to also know from you any interesting another climate litigation case that you could talk about that was like an inspiring win. Maybe not as monumental as ICJ, but I think every little win is just inspiring, and it'd be just nice to hear from you. Anything that you can recall to share.
Well, there's so many climate cases, right? Like what is around there's 2,800 climate cases filed to date, and as we know, many cases are climate cases. They have huge implications for climate that are not necessarily categorized as such. But you're absolutely right. This case is falling within a landscape of other powerful climate wins. We saw a really strong ruling also from the Inter-American Court of Human Rights, also defining states' human rights obligations in relation to climate change. Last year, we saw a powerful ruling from the International Tribunal for the Law of the Sea, defining states' obligations, climate obligations as well in that ambit. We saw Klima Sinirinen, making it very clear that the climate crisis is a human rights crisis and that states have very strong legal obligations to take action to protect the environment and people. So all across the world, we've been seeing cases, and now there is also a case at the African Court of Human and People's Rights that is asking for more clarity on states' obligations, which will help deepen all the findings from these other international tribunals from a regional perspective. Because as we know, the way climate change manifests in different regions can look different. It is very serious and very the impacts are experienced across the world, but it can take very different forms. Therefore, regional response also has to take that into account. So I think we've seen some really powerful climate cases, and just there's more coming. And now I think we will. I mean, we've already seen strong climate litigation on targeting corporations, because corporations can have such a disproportionate have contributed in such disproportionate ways to the climate crisis. So we're seeing more and more cases being brought to ensure corporate accountability. And this case, along with some of the others as well, really strengthens the hands of those seeking to hold corporations accountable.
Yeah, that's very heartening to hear. And if you would like to share your personal reflections throughout the journey of fighting for climate justice and being part of the movement, and anything that you'd like to share before we close this wonderful conversation, which I don't want to close, but it would be nice to hear from you just something from your personal reflections as your journey in the space and how it's been. Yeah.
I think it's a hard space to work in because we see such horrific impacts happening and happening because of conduct that can be traced back to countries and corporations who understand what the implications are, who've known from the 1960s what would happen, and who still continue on this destructive path. That piece of it and what it means, like you talked about Uttarakhand, you talk like when you're with communities and you see the impacts, it's really hard. And it's really heartening to see that across the world, across generations, whether it's on the streets, whether it's in the courtrooms, whether it's in the legislatures, people are fighting back to protect their territories, their oceans, their like the precious ecosystems, that there are many people all across the world that are fighting for a just and livable future for all. And in this case in particular, it has been deeply inspiring to see what youth leadership means and how committed they are to structural change, which many movements in India have fought for very long, but how they come to the mainstream spaces where it's all about carbon and it's about technical issues. And they're like, it's also about people. It's also about our oceans. It's also about our land. That, and this is also really critical that, yeah. And whether it's apartheid, whether it has been slavery, like we have seen what was previously considered intractable. We have seen shifts happen because of people's movements and the way people's movements have taken on the climate and environment justice issue. That gives great hope. Yeah, so I think I'll stop there.
That's very encouraging, Joy. And I have to thank you for so kindly and patiently taking us through what the basics of the ruling has been, getting into the details of what happened, its implications, and what to look forward to in the future. This has been a really wonderful conversation. And thank you so much for your time doing this for us.
Thank you, Manjari. Thank you so much for having me.
And congratulations on this big win. And to everybody in the ecosystem who's worked so hard to make this happen, and that really sends a really message of hope to everybody working in the climate space. So yeah, congratulations on that too.
Thank you so much.